Judgment in the appeal of the Queen on the application of ZH&CN and the London Boroughs of Newham and Lewisham.
Lord Hodge will explain the judgment of the court.
The Protection Against Eviction Act 1977, as its name suggests, protects people who occupy a dwelling under a tenancy or a licence from summary eviction. It requires the owner A to give a minimum period of notice and B to obtain a court order before evicting the occupant. The eviction is then effected by court officers. Part 7 of the Housing Act 1996 imposes duties on local authorities to provide accommodation to homeless persons in priority need if they have not become homeless intentionally. While the local authority investigates whether an applicant meets those conditions which place the authority under the duty to provide accommodation, it is obliged under Section 188 of the Act to provide interim accommodation in the short term. The issue in these appeals is the relationship between those two statutory regimes. In particular, the question is whether the local authority or other owner of the property is subject to the limitations of the Protection Against Eviction Act when it seeks to regain possession of accommodation provided on an interim basis under Section 188 of the 1996 Act. The appellants were children of families provided with such interim accommodation by local authorities, which had arranged for private owners to grant them licences to occupy property on a day-to-day basis. Their claims to be given accommodation as homeless persons were rejected after investigations. When the local authorities then sought to evict them, they raised proceedings for judicial review, arguing that they could not be evicted without a court order. They also argued that their eviction without a court order breached their rights under Article 8 of the European Convention on Human Rights. After the Court of Appeal dismissed their claims, they appealed to this court. By a majority of 5-2, this court dismisses the appeal. The court also holds without dissent that the appellant's Article 8 rights had not been breached. The difference in view essentially is about what is meant by a dwelling, the word a dwelling, in the Protection Against Eviction Act. The majority takes the view that it suggests a greater degree of settled occupation than the word residence, and that it doesn't cover a property provided on a licence on a day-to-day basis pending the completion of the local authorities' investigations. The minority considers that the term dwelling covers accommodation provided on a short-term, provisional or precarious basis, and that people in such accommodation should not be summarily evicted. Lord Carnwath gives a judgment concurring with the majority in which he sets out his views on how settled practice could, in appropriate circumstances, be an aid to the interpretation of a statute.